Violation of Probation, NJ. Update 2017. Hello, my name is Stephen A. Gravatt. I've been a New Jersey criminal defense attorney for approximately 29 years. During my career, I've handled many criminal matters, and I've handled many violation of probations for clients. Today, I want to explain to you what violation of probation is, what violation of probation is not, and how new laws affecting the way bail is set or pretrial release may have bearing on whether you have to stay in jail longer or you can get out of jail at all if you are arrested on a warrant complaint for violation of your probation. Okay, what is probation? Probation is a sentencing animal. Let's put it that way. Suppose you're accused of a third or fourth degree crime. For possession of oxycodone. Maybe you have 5 pills in a bottle and you don't have a prescription and it's oxycodone. That would be a third degree offense. Suppose you either plead to it or are convicted of it. Now the question would be, what is the court going to do with you on sentencing? Of course, there is a presumption of non-incarceration on third and fourth degree offenses. So a judge has to decide, is this the kind of person that we have to put in jail because he's dangerous? Or is this the kind of person that can be given some terms and conditions of probation, which he will be required to follow, not disobey, so he can stay out of jail and live his life? So that's what probation is. You have already expended most of your constitutional rights. They've been subsumed into the idea that you either pled guilty and voluntarily gave them up in exchange for a lesser sentence, or you were found guilty at trial and therefore you no longer have pretrial constitutional rights. Okay, so here are the terms and conditions that you usually have to live up to. A, you can't be convicted of any new criminal charges. You're not even supposed to get any new criminal charges, but sometimes they will overlook them if they're not serious. You've got to report to your probation officer when they tell you to. If you were told to do drug counseling, you must continue to do drug counseling, continue to give urine samples if you're ordered to do that. You must stay employed if you are employed and can be employed. And a few more of those garden variety type requirements. The most common way people get in trouble with this is either it's a drug offense or it's some other kind of low-level criminal indictable offense. A few months go by, 6 months go by, something else happens in their lives, and boom, they get a new drug charge. That's a violation of probation. Now, what's the remedy? Well, you're supposed to be taken into custody, or you can be taken into custody. It means arrested and incarcerated immediately, and then given a hearing. And the gist of the hearing is, we are accusing you, the state is accusing you, we are accusing you of violating the terms and conditions of your probation. What are you going to say in your own defense about that? And then when we decide that you have, what are we going to do with you? Are we going to put you in jail and revoke your probation? Or are we going to modify your probation, maybe extend it and let you continue, but jump through a bunch more hoops for a longer period of time because, you didn't listen to us and now we're going to make you listen. So that's the situation. Now, I've handled many of those cases, and I've been able to help people by negotiating with the probation officers, with the prosecutor's office, and conferencing cases with the judge who's going to be deciding the matter, and becoming an advocate for my client to explain why they don't deserve incarceration. Because as you can see, that would just pretty much ruin somebody's life. If you commit a third-degree offense, it's a minimum 3 years, maximum 5, presumptive 4. That means state prison, and that can ruin someone's life. Okay, so now we have this new law coming into effect that says if a warrant complaint issues for you, meaning indictable serious complaint, you must be arrested, you must be placed in the county jail, you must wait 48 hours to get a hearing before a judge to see what the terms and conditions of your release pretrial will be. Well, you already passed all that if you're a VOP. Now the question is there some basis upon which you can be released to await the term or the hearing date to determine what to do with you? And the answer is there probably can be in most cases, assuming that we're not talking about second-degree or first-degree crimes. My name is Stephen Agravat. My cell phone number is 732-337-7922. My website is www.njdwicriminaldefenseattorney.com. If you're in this kind of a jam where you have a loved one, a spouse, a son, a daughter, a husband, a wife, who needs help, I'd be happy to help you. And I have helped many people out of this kind of jam. So please give me a call. Whatever it is that you're facing, I can probably make it less bad. Thank you.